Today, we'll discuss how your firearm could be confiscated in Connecticut and how you may be able to get it back. We'll cover scenarios, legal frameworks, and steps. First, how a gun might be confiscated. A risk warrant, or red flag seizure, can occur under the state's imminent harm law. A protective order in a domestic violence situation may require firearm surrender. A criminal arrest or charge can lead to law enforcement holding your weapon as evidence or suspending your rights. Revocation or suspension of your eligibility certificate or permit can also result in de facto confiscation. To get your gun back, first understand why it was taken. Connecticut offers several legal pathways. Risk warrants for imminent personal injury fall under Section 29-38C of the Connecticut General Statutes. A judge can issue a warrant to seize firearms if there's probable cause of imminent risk of personal injury and firearm possession. After seizure, a court hearing must occur within 14 days to decide on firearm return or a one-year hold. This is Connecticut's red flag law. Protective orders in domestic violence cases allow immediate firearm seizure. Connecticut law mandates firearm return within 7 days of seizure unless disqualification or court order applies. If your permit is revoked or your weapon is held as evidence, your possession rights may be suspended. For example, Section 53A 217 outlines criminal possession prohibitions. Knowing which applies is critical for next steps. Your firearm has been seized. Now, are you legally eligible to possess firearms again? You must not be disqualified under state law. If seized under Section 29-38C and no risk was found, return is required. If the state fails to prove risk, the court must order firearms returned as soon as practicable if you're eligible. If you have a protective order, felony, or mental health commitment, you might be barred until disqualification ends. If your gun was evidence in a criminal case, that case must be resolved before you can request its return. Ensure you are not legally disqualified before requesting return. Remedy any disqualifications first. You know why your firearm was taken and believe you're eligible. What's next? Find where your firearm is and request its return. Identify the agency holding it. Obtain paperwork, warrant, seizure inventory, case number, and any protective order. Warrants must list all seized firearms. Submit a formal written demand for return, citing your eligibility, case number, and statute, and request a timeline. Ask about return conditions. Agencies often require proof of compliance, permit reinstatement, or a safe storage affidavit. Stay proactive. If you prevailed in a Section 29-38C court hearing, the firearm should be returned as soon as practicable. If disqualified, the agency may allow transfer to a licensed dealer or another eligible person. For example, Section 29-38C subsection E provides for transfer under specific conditions. If the agency refuses return or a court orders it held, legal action may be necessary. Under Section 29-38C subsection D, the hearing to determine firearm return must occur within 14 days of seizure. If the court finds you pose a risk, firearms may be held for up to 1 year. After that, you can petition to terminate the order. Subsection F allows a petition at least 180 days after the hearing to terminate the order if no longer a risk. To challenge a protective order surrender, file a motion to terminate it and request court-ordered return. If seized as evidence, file a return of property motion after criminal proceedings conclude. Procedures vary by court. If disqualified, file a reinstatement petition under Connecticut law. Once eligible, you can request return. Due to complexity and deadlines, consulting an attorney experienced in Connecticut firearms law is highly recommended. Track important dates, warrant service, hearing, order expiration. Missing deadlines can result in losing rights. To maximize your chances of getting your firearm back, follow these best practices and avoid common pitfalls. Act quickly. Upon seizure, determine the basis, identify the hearing period, and seek legal representation. Document everything. Keep copies of warrants, inventories, protective orders, and permits. Confirm your eligibility status. Address any potential disqualifiers early. Demonstrate safe storage and compliance. This supports your credibility even after regaining your firearm. Be polite and cooperative with the agency. If you can't possess the firearm, ask about transferring it to a licensed dealer. Avoid waiting passively and missing the 14-day hearing under the risk warrant statute. Do not assume return is guaranteed. Address any disqualifications first. Do not ignore the specific statute applicable to your case. A wrong motion can cause delays. Taking possession before proper procedures are complete could lead to criminal liability under Section 53A217. Never rely solely on verbal promises from law enforcement. Always get everything in writing. If this video was helpful, please like, subscribe, and ring the notification bell for more updates on firearms law in Connecticut and beyond. To recap, firearms in Connecticut can be confiscated via risk warrants, protective orders, arrests, or permit revocation. To get it back, identify the applicable category and confirm your eligibility, ensuring no disqualifiers remain. Then, contact the agency holding your gun, request its return, and provide eligibility proof. If issues arise, you may need to file a motion or appeal. Timing is crucial. Follow best practices and avoid mistakes. The process is technical. Always consult a Connecticut licensed firearms attorney when in doubt. Thanks for watching The Right Slant. Stay informed and, more importantly, stay safe.